Today we talk about international considerations and protections for trade secrets. As companies operate in an increasingly globalized economy, protecting trade secrets requires navigating complex international legal frameworks and tailoring strategies to address jurisdictional nuances. With the rise of remote work and cross-border collaborations, businesses must adopt layered protections that account for varying laws on non-compete agreements, employee mobility, and trade secret enforcement. Now we explore key international considerations and safeguards to mitigate risks in this evolving landscape. Let's talk about the international legal framework and the challenges. First, you have is a divergent set of trade secret laws. Trade secret protection varies significantly across jurisdictions. While the US relies on the Defend Trade Secret Acts or DTSA, and state law relies on laws like California's CUTSA, other regions have distinct frameworks. For example, in Europe, they have the EU Directive 2016/943, which requires key member states to protect trade secrets against unlawful acquisition, use, and disclosure, but allows for flexibility in implementation. The TRIPS agreement mandates basic trade secret protections for WTO members, although the enforcement standards differ. NAFTA and the USMCA includes provisions for protecting undisclosed information, particularly in pharmaceuticals. The key challenges would be the jurisdictional conflicts. Trade secret theft involving multiple countries often leads to disputes over which laws apply. For example, U.S. courts may assert extraterritorial jurisdiction if the misconduct affects U.S. commerce, but enforcement abroad remains uncertain. And this has occurred between cases where there was a U.S. company that faced trade secret misappropriation, but the accused parties are in other countries, such as in China. There's also cultural differences. In some jurisdictions, employee mobility is prioritized over the trade secret restrictions, and therefore complicating the enforcement of that. So how do you adapt the employment agreements for global teams? If you're a California startup, you start with California compliant baselines. California has a strict prohibition on non-competes under SB 699 and AB 1076, and it makes the California Employment Agreement a useful template for global teams. So the key elements in the template would be, number one, confidentiality clauses. These clauses should explicitly prohibit disclosure of trade secrets post-employment and enforceable even in non-compete hostile jurisdiction. You should also localize your contracts. Use jurisdiction-specific NDAs and non-solicitation clauses. So, for example, Germany allows limited non-competes with compensation, while Japan permits them only for senior executives. Second, mitigating employee mobility risks. For your high-level personnel, you may want to require your senior vice presidents and your senior executives to reaffirm confidentiality obligations during exit interviews and return all company data. For cross-border onboarding, you should train the international hires on trade secret policies in their native language to ensure comprehension. You should have 4 pillars of trade secret protection. To comply with reasonable measure standard under U.S. international law, companies should adopt a multi-layered approach. First, contracts and policy. You should have confidentiality agreement. The NDA should specify what is protected information, such as algorithms and customer lists, and include the whistleblower protection mandated by DTSA. For invention disclosure processes, you should flag the trade secrets during the patent reviews so that you can maintain the secrecy for non-patentable innovations. Second is technological safeguards. You should have access controls that restrict sensitive data using role-based permissions and multi-factor authentication. You should have data loss prevention or DLP systems that monitor and block unauthorized transfers of confidential files. 3 is physical security. You should have secure facilities. Use batch access and locked storage for prototypes or manufacturing processes. And you should have a clean desk policy to prevent unauthorized access to physical documents. 4 is education and training. You should have regular workshops where you train the employees on identifying the secrets, For example, negative R&D result, that can be a trade secret, and phishing risks. You should have cultural integration. The trade secret should foster, you should foster a need-to-know mindset, particularly industries in tech where open collaboration is common. How do you enforce your trade secret in cross-border disputes? You should leverage the international treaties such as TRIPS or USMCA provisions to pursue claims in signatory countries. You should have local partnerships. Work with in-country counsel to navigate the regional laws. So, example, China's anti-unfair competition law requires proof of confidentiality measures for trade secret claims. You should set up your foundations so that the case in the local country will go smoothly using knowledgeable in-country counsel. You should have forensic readiness. Maintain access logs and document marking to demonstrate reasonable efforts in litigation. So in short, in a post-non-compete era, businesses must prioritize adaptable, jurisdiction-aware strategies to protect trade secrets. By combining robust contractual safeguards, technology, physical security, and ongoing education, companies can mitigate risks proposed by global employee mobility and fragmented legal standards. The four-bucket framework remains critical, but its implementation must evolve to address the unique challenges of cross-border operations. If you have any questions, feel free to visit patentpc.com. We're glad to answer your questions.